So the final topic that we have to deal with in this set is the difference between a condition and a warranty in a term. And why it's important is that whether a term is a condition or a warranty has an effect on the remedy that's available, on what you can do if there's been a breach of that term. So let's pop into it. So a remedy is really about what options are available to you if a term has been breached. So if one party breaches a term of the contract and they're not protected by a disclaimer, then there are a number of possible legal remedies. We focus on partial performance, so when a party complies with some terms but breaches one or more of the other terms. Can the other party terminate the contract and sue for damages? So again, this is based upon case law, and our first case is Associated Newspapers and Banks. And this involved a contract between a newspaper, Associated Newspaper Limited, and a cartoonist, Banks. He did a weekly cartoon, and in fact it was a very famous cartoon called Ginger Meggs. As part of the contract, the newspaper agreed to publish the comic on the front page of the comic section. But for 3 weeks in a row, they actually published it on the third page of the newspaper. Now, this was obviously important to Banks because if you put it on the front page, more people will read it. It increases the likability of your cartoon. And in the future, if more people like it and follow it, then you're going to be able to charge more money for it. So this was quite important, and Banks got upset. And after the third time of putting it on the third page, he told the newspapers that he was terminating the contract, and he entered into a contract with a different newspaper to publish it on the first page. So the question comes, was Banks entitled to terminate the contract? And the court held here that yes, he was entitled to terminate the contract. Why? Well, the term that it would be published on the front page was so important to Banks that he wouldn't have entered the contract without it. So that's what a condition is. A condition is so important. Okay, this is really critical. So important, you wouldn't have entered the contract without it. Okay, and if you breach a condition, you can terminate the contract and sue for damages, which Banks did. Here we have an example of a condition. In the absence of such a fundamentally important term, the party favoured by the term wouldn't have entered the contract in the first place without it. So important, it had to be in the contract or you wouldn't have entered the contract. Now we can contrast this with the famous case of Bettini and Guy. So in this case, Alessandro Bettini was a singer and Guy was the promoter. They enter a contract according to which Bettini is going to sing for Guy at various events over a 15-week period. And Bettini would have to attend rehearsals for 6 days prior to the first event. But he missed 4 days of the rehearsals due to the illness. So what we have is 6 days of rehearsals, and then we have 15 weeks of performances. Now, Guy, the promoter, seeks to terminate the contract, but here it was held that he wasn't able to terminate them. Why? Well, the requirement for Bettini to attend rehearsals was not a condition. It wasn't of fundamental importance. So Guy wasn't entitled to terminate the contract. Instead, this is an example of a warranty. Why? Well, because it's about the actual performance where the major contract is. If Bettini hadn't turned up to opening night or had missed a lot of the performances, that would have a breach of a condition. But because he'd missed several of the rehearsals, that wasn't fundamental to the contract. So if it's not fundamental, the term is a warranty. And if a warranty is breached, the injured party must still perform the contract. So the contract is still valid, and you can only get damages for any loss suffered. You can't get out of the contract. That's why it's so critical to understand the difference. Okay, so a condition is a term of the contract that's of fundamental importance. Without that term, the party favoured by it would not have entered the contract in the first place. If you breach a condition, you can confirm the contract and get damages, or you can terminate the contract and get damages. The choice is up to you. A warranty, on the other hand, is of lesser importance. So you would have entered the contract even without that term. If a warranty is breached, the injured party must still perform their part of the contract, but they might have the right to sue for damages. Whether a term is a condition or a warranty is determined objectively, what a reasonable person would think, not what they actually thought, taking the conduct of the parties and the context into consideration. Now, just to reiterate with some of our remedies, damages. A party can get damages where there's a breach of contract by the other party, a breach of a collateral contract, or fraudulent or negligent misrepresentation. The objective of the court in awarding damages is to restore the other party to the position they would have been in. Okay, so it's not like winning lotto. Okay, you only get as much money to put you back into the position that you would have been if there hadn't have been a breach. Sometimes the party who's been harmed can say, look, damages aren't enough. Then the court can decide to provide an equitable remedy, which we've already found out about. You can get an order of specific performance, which directs one party to fulfill their contractual obligations, so they've got to fulfill the contract, or you can get an injunction, which forbids someone from engaging in a particular conduct. While we have used some old cases, you'll also note that these concepts are as applicable in modern day commerce. Okay, that's a lot of ground we've covered in contract, but hopefully it gives us that basic understanding of when a contract's formed, what a contract is, what's in the contract, are we sure that we've actually got a contract in place, how disclaimers are handled separately, and then what happens when we breach a particular term, whether that's a condition or a warranty.